Hi, everyone. Good evening, good morning, wherever you are. I'm attorney Yael Brudner, and I'm here today to answer your immigration questions. It has been so nice to receive your questions during the week. Thank you for everyone that sent us your questions. I picked the top questions that I think would be the best for everyone. However, if you are watching live today, please feel free to write your questions in the comments and I will promise to get to them if I can. And if you're watching the recording of this, feel free to jot down your questions and we will answer them at a later time. And just in general, if you are here, thank you. Please like our page and subscribe to our YouTube channel so you can get more updates. About more live streaming events and immigration updates and a lot of great information. If you are joining right now, thank you so much for joining. Again, I am attorney Yael Brudner. Our office is located here in Southern California. However, we do represent clients from all over the United States and around the globe, actually. So wherever you are, we can help you. Uh, and that's it pretty much. Should we jump into the questions and see what we got for tonight? Let's do it. Okay, I am streaming on Facebook and YouTube Live, so if you have questions on either one of those channels, feel free to write them as we go. Okay. Hi, hello everyone that's joining. Thank you so much. Okay, so this question is, I just got my green card. Can I petition my parents? So first of all, congratulations on becoming a resident and getting your green card. It's amazing, amazing news. Um, One of the first questions that a new resident asks is, who can I petition? Can I help my family? And you definitely can. However, as long as you are a resident, you do have some limitations. So a resident, a green card holder, actually cannot petition their parents. Okay, a green card holder can only petition their children and their spouse. Actually, their unmarried children and their spouse. So, in terms of children, you can always petition your children, no matter how old they are, as long as they are not married. And then, in terms of your spouse, you can petition your spouse. However, with your parents, you will have to wait until you're a US citizen to petition your parents. Okay. The good news is, though, that if you do petition your parents as a US citizen, it's considered an immediate relative category, so there's no wait, and the process is relatively quick. Okay. But really good question, and thank you for asking. Okay. Let's see. Hi, Bruno. Thank you for asking your question. Let me read it real quick. I've been a resident since '06, but I got denied for citizenship for a charge I was not familiar with and I had no knowledge of. My residency ends next year, so should I be worried about that getting renewed? Okay, well, first of all, that probably is very frustrating and alarming to go to your citizenship interview and find out that you have a charge, you have something on your record, and you didn't even know. So, in terms of your question, for residency to renew your green card, you should be able to renew your green card. Generally speaking, you can still renew your green card, but I would definitely recommend to get an evaluation of your case, to get a copy of your criminal record so you can do a background check and see exactly what's on your record. If something's on your record and it shouldn't be, you can get that off of your record. Okay. And I would love to help you with that. So if you want to reach out and call us, feel free to do that. My first advice to you would be to get a copy of your record, see what's on there, and go from there. But regardless, you should be able to renew your green card. Okay, so thank you for clarifying. It was attempting to buy cigarettes under 15 years ago, and I've never smoked. Wow. So you can definitely dispute that with the help of a criminal attorney. Okay, so if there's something on your record, it could be some kind of confusion with the name, something's going on there with your record. Criminal law is not my expertise, but definitely I would reach out to a criminal attorney to figure what that, what that is about. And attempting to buy cigarettes also should not be a reason for your naturalization to be denied. So definitely, I would schedule a consultation. Let's talk about this more in detail. Okay. Perfect. And just in general, there's no limit to how many times you can apply for naturalization. So even if you were denied one time, you can apply again. Okay, this time with an attorney, with representation, someone that can advocate for you on the spot. Okay, awesome. I hope I helped, Bruno, and I hope you reach out to us so we can talk one-on-one. Okay, Eric is asking, with submitting documents for I-130, is it necessary to get notarization or apostille for documents? Depending on what the documents are, usually I do not get them notarized. Apostille is not something that the US usually requires. It's usually other countries require that US documents get apostilled. It's not mandatory to get anything not notarized. Sometimes I would notarize some certain affidavits. If you are including affidavits from friends and family attesting to your relationship on the I-130, then sometimes we would do that, but it's not legally required to get it notarized or to get an apostille. Perfect. Okay, so let's see. There's a question here. When you enter the country illegally with false documents, you need to do a sorry. So this question is pertaining to, I'm assuming if you want to apply for your green card, but you have in your past a situation where you entered the country using someone else's documents, can you ask for forgiveness? And the answer is, generally speaking, yes, you can ask for forgiveness as long as you have a qualifying relative. Okay, so to ask for forgiveness through a waiver, it's called a waiver, then you would need to either have a US citizen or a green card holder spouse or parent. Okay, if you have one of those, and if it is determined that you need a waiver, you will be able to apply for it in your green card process. Okay. Let's see. Yes, and you're clarifying the I-601. The I-601 is the form that you file when you're filing for a waiver. Okay. Perfect. Okay. OC is asking, my daughter was born here. I came with a visa and overstayed. Can she help me get my green card? Well, generally speaking, if your daughter is a US citizen and she's over 21 and you enter the United States with a visa, generally speaking, she can petition you for your green card and you can apply for it here in the United States. Okay, there are certain inadmissibility factors that if you have on your record could affect your case, but generally speaking, yes, the answer is yes. Okay, that's great. She has to be over 21 though. Okay. Thank you everyone for these great questions. Feel free to write your questions down in the comments and I will try to get to them as we go. Okay, so she's saying that your daughter is going to be 21 in 3 years. Okay, so she can help you when she turns 21. Okay, so coming up soon. Okay. Okay, let's see. Mohammed is asking about a court case. I'm an asylum seeker. The judge terminated my case. Let's see. The judge terminated my case from court because he says notice to appear is defective. We filed the case with USCIS, is it possible to get back to court? So this is a very specific question talking about immigration court and termination. I understand that you're interested to get back to court to have a trial on your asylum case, right? If you no longer have a case with the immigration court due to an effective notice to appear, there could be some technical issues there. I would just recommend at this point just to schedule a consultation to get an assessment on your case. Okay. Okay. Next question. Thank you so much for these great questions. I'm a US citizen. I'm petitioning my wife for her green card. Can her kids be in her petition as well? Okay. So, as a US citizen, you can definitely petition your wife for a green card. Okay. That would be a marriage-based green card that you can do. Now, what about her kids? Her kids, if you guys got married before their 18th birthday, so before they turned 18, they can be considered your children, and you can petition them. But please notice, you have to petition them directly. This happens a lot of times where folks think that they can petition the kids together with the parent, with the mom or the dad, but it's separate petitions. So if she has 2 kids, and you guys got married before their 18th birthday, then you have to petition your wife and you have to petition for each of your children. So it'll be 3 separate petitions. Okay, you are eligible to petition them and they can get their green card through you as their step parent. However, they need their own petition. Okay. They can't go in her petition. And it might sound as if it doesn't matter, how they go under, but it does matter. Okay, they need their own separate petition. Okay, if you want specific help with your case, please feel free to reach out. The number is here on the screen. 714-794-9366 is our number. If you want to have an individualized evaluation of your case, we would love to do that. Okay. Okay. I am here visiting my boyfriend and he just proposed. If we get married, can I apply for the green card? I'm here as a visitor. Okay, so this is a very common question and a very common scenario that happens, that people come to the United States to visit their significant other. It's a long distance relationship and they come in just for a visit, but then they decide to get married. Okay. And if that is your case and your boyfriend is a US citizen and you decide to get married, then you can absolutely apply for your green card here in the United States. Okay. You can do it here even though you entered as a visitor. Okay. As long as you entered with your visa and your spouse is a US citizen, you can get married and apply for your green card here in the United States through a process that's called adjustment of status, okay? Which is just a fancy word for saying applying for a green card in the United States. So even if you entered as a visitor, and even if you overstayed, even if you're no longer in status, you can apply for, generally speaking, you can apply for your green card here in the US. Okay. Let's see. Okay. This question is the following question. Can you explain when can somebody apply for a U visa? Okay, absolutely. Absolutely, I can explain. So a U visa is a visa that is available for people that have been subject to a crime here in the United States, and they helped law enforcement with this crime, meaning they reported the crime to the police. Okay. There are specific crimes that would qualify for the U visa. So if you were harmed or you were a victim here in the United States of a crime, unfortunately, then there needs to be an assessment to see what exactly happened. There's certain crimes that would qualify for the U visa. And these are generally speaking serious crimes. Things like domestic violence, any kind of assault, so sexual assault or serious assault or any kind of violent crime, kidnapping, things like that will be considered qualifying for a U visa. Okay. So you have to have been a victim of a crime in the United States, of a qualifying crime. So one of those crimes that are considered um, to be a qualifying crime, and you have to report the crime to the police. Okay. The first step with a U visa case is that you have to get your U visa certified first by the police. So the police needs to say that you did indeed report your crime, report what happened, and you are available for questioning. You did assist law enforcement, and then once the police or law enforcement agency certifies this, then you can apply for your U visa with immigration. Okay. Now, if you were a victim of a crime, if this is applicable for you, I highly, highly recommend to schedule a consultation with an attorney, because things could be time sensitive and you don't want to miss out on this. If you've already been a victim, then you should check out with an attorney to see if you qualify to get a visa based on this crime that happened to you. Okay, we'd love to help you. Please reach out to us. Okay. Okay, perfect. If you want to contact us, you can call us at 714-794-9366. Okay, the number is kind of running here on the screen, but you can reach out to us for questions that way. Okay. The next question is about DACA. I'm on DACA and I want to go visit my grandmother in Mexico, but she's not very sick. Would I get approved for advanced parole? Okay, so for those of you that don't know what DACA is, DACA stands for Deferred Action for Childhood Arrivals. And it is for, a lot of people call it the dreamers, individuals that came to the country, to the United States unlawfully, or maybe they overstayed and they're here now without status and they meet certain requirements. They could apply for something called DACA, which is Deferred Action for Childhood Arrivals, and it gives them protection from deportation and it gives them a work permit. Okay, so that is DACA. And DACA does, like I said, gives you protection from deportation and gives you the ability to work here legally in the United States. However, it doesn't automatically give you permission to travel. If you want to travel outside the country, you need to apply for something called advanced parole. Advanced parole is a travel document, and it's only given if you meet certain conditions. So if you meet certain requirements, you have to show that you have a specific need to go. So either a humanitarian need, an educational need, or a financial need. Okay, so there's a reason for you to travel and a reason for you to receive advanced parole. And getting advanced parole is a huge, huge benefit, right? If you entered the country unlawfully and you are able to travel with advanced parole and DACA out of the country and come back, that's a huge benefit later on if you want to apply for a green card in the United States. Okay, so I am encouraging my clients to apply for advanced parole. So in this question, the person that's asking is saying that they want to go apply for advanced parole based on their grandmother's health. Well, this would be a humanitarian reason, right? You want to go see a sick relative. Now, that's true. You have to show that it's a humanitarian, it's a strong, compelling reason, right? So, the stronger the reason to go, so the God forbid, right? The worse your grandmother is in terms of her health, the easier it would be to get advanced parole, because you have to show humanitarian reason, right? There's a really compelling reason for you to go. If your grandmother has the cold, they're not going to let you go. They're not going to approve advanced parole for you. So in this case, you have to be creative, right? You have a family member, they're not in excellent health, but they're not, God forbid, dying, right? So it's in the middle. So here we always recommend, consult with a professional that knows how to write these advanced parole requests, and see how you can present your case in the most compelling way. Obviously, you have to be truthful and honest, but you can present it in the best way. Okay. She's not very sick, but she is sick. She has some conditions. So can you talk about those? Can you bring doctor letters? Can you bring expert letters? Can you verify her medical condition in any way? Okay. Can you write a statement talking about how important it is for you to go visit your grandmother while she's still in relatively good health, right? You don't want to wait until she's dying. You want to be able to enjoy your time with her. Okay. So there's ways to approach this, and I recommend trying for it because you have really nothing to lose to try. Advanced parole for DACA recipients is a discretionary benefit, so immigration does not have to approve this, but they can. And if it's available, I think you should go for it. Okay. Perfect. For those of you that are joining now, I will take some more questions. So if you have any questions, please write them in the comments. And if you're watching the recording of this, then please still write your questions and we'll get to them later. And let's jump to a few more questions. Okay. Can I petition my husband even if he entered the US illegally? Super common question. We get this question every day. Okay, there's someone that came into the country unlawfully. They've been here for several years. Maybe they've lived here their entire life, and then they get married to a U.S. citizen, and they want to know how can they get the green card based on this marriage. So, generally speaking, if you're married to a U.S. citizen, the U.S. citizen can petition you for a green card. However, the law says that you can only apply for your green card in the United States if you enter legally, right? You have to have a legal entry to apply for the green card here in the United States. So technically speaking, generally speaking, if you entered unlawfully and you're married to a US citizen, you can go through the process, but you would have to go back to your home country. You cannot do it here. You might need a waiver to forgive you for the time that you've been here when you leave. Okay? But at the end of the day, there is a process, there is a path for you for most cases, as long as you entered one time, right? If you entered more times, there's multiple entries or any other factors that can make the case a little bit more complicated, okay? Now, also, it's really important to know that if this is your situation, if you are married to a US citizen, but you do not have a legal entry, I really, really recommend to talk to an immigration attorney because there are exceptions to the rule that says that you can only apply for the green card in the United States if you enter legally. Talk to a lawyer, make sure to see maybe you qualify for one of these exceptions. We've helped hundreds of people in the United States get their green card, get their papers without having to leave, okay, because they met one of the exceptions. So if this is your situation, I encourage you, don't file your case by yourself. You need help, reach out to an attorney. We'd love to help you, okay? Okay, let's see. Okay, what documents do I need to petition my wife for a marriage green card? I love it. We're getting a lot of questions about marriage-based green cards, and those are one of the most common ways to get a green card here in the United States is through marriage. Okay, that you are a U.S. citizen or a lawful permanent resident, and you want to petition for your spouse. So it's a super common way. But what documents do you need? Like, where do you even start? So to petition your spouse for a green card, it's your burden. It's your responsibility to prove that you're eligible. So the first thing you need to prove is that you are a US citizen. So you have to show proof of that. You need to show that you're legally married, right? So proof of that, your marriage certificate. You need to show that any previous marriages were terminated. So if you were married before, you have to show that the marriage ended officially, either by divorce, annulment, or death. Okay. You have to show that the marriage is real and valid. So it's your responsibility to provide proof of your marriage on paper. So pictures, affidavits from friends and family, anything on both your names, utility bills, leases, tax returns, Costco membership, cell phone plans, anything that you can think of. It's your burden to prove that you meet the requirements. Additionally, you have to show financial documentation. So if you're the petitioner, you have to show that you can financially petition for your spouse. Tax returns, W-2s, 1099s, to show that you have minimum funds to sponsor your wife. Finally, your wife will have to show proof of her identity, for example, her birth certificate, her passport, and things like that. Okay, so marriage-based green cards are very document intensive. There's a lot of documents because you have to file your case and you have to show on paper that you qualify. Okay, so if you have a marriage case pending or you're thinking of filing a marriage case, we'd love to help you. Feel free to reach out. We'd love to evaluate your case at a consultation. Okay, guys, I am going to end today's live show. I will be here back next Thursday, same time, 5:30 p.m. Pacific. If you have any questions, please send us the questions in advance. It's really great to get them in advance and prepare them for you. If you want to reach out to talk to me for a consultation, one-on-one, private, reach out through, send us a message or reach out. You can call us. The number's here on the screen, 714-794-9366. And we'd love to assist you. And finally, don't forget to like our page and subscribe to our channel to get more updates about immigration and these kind of events. So until next week, have a great week and see you soon.